have to share police powers with the president as stipulated by the constitution. We do not have a federal government police force. We have the Nigeria Police Force, which shall be administered, organized, and supervised by the Nigerian Police Force.
No, my lord, I want to say something. I want to say something here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the Matters Council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court.
Is this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord. I think I'll be in cross-examination.
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing.
All right, good evening and welcome to Legally Speaking on Planet Radio 101.1 FM and Star Times channel 421, right, that's Spectrum TV on channel 421 of Star Times. My name is Anthony Ebuk, and probate, intestacies, and inheritance of properties of a deceased person. Okay, recently, or very commonly in Nigeria, Akwa State. All right, so what's the next of kin, and why do people really think it has legal significance? We'll discuss that and see how we enlighten them.
Very much.
All right. Okay. Did I hear you, or maybe I have to tone this too? So Hannah, you've been hearing people fight on issues of next of kin. If the husband goes to the bank and realizes the wife named the named a sibling, biological sibling and next of kin, and it breaks the marriage. And vice versa. Sometimes wives go to fight to remove their husband's name and put their son's name as next of kin because of obvious reasons, right? Now, has it ever bothered you why this happens? Okay, what's your
point of contact for information? I also used to think that the next of kin is the person that will.
But I can imagine that a lot of people don't think there's anything funny about it. In fact, they just believe that as next of kin, it means you. And now, people go as far as.
I believe that people call it Adiakba.
Adiakba. That's in the Bible. Adiakba means especially fight over who will be the chief mourner on burial programs. They want their names to appear there, and really it splits families when you see who was the chief mourner. They say it was,
I don't know about chief.
No, really, I have. They say chief mourner, the first son, if there was a half brother and things like that. Sometimes the man wasn't.
Well, I think fighting for the. I don't know what's special, because I'm not a expert. So
let me explain that part.
What it's supposed to
there are
be.
times
What's supposed to be special
about being firstborn, being chief mourner.
So
there are times you have a family where a male child doesn't succeed or survive the deceased, and when that happens, you hear people bringing uncles.
Did you not say anything about money and who is chief and who is
a servant mourner?
Vice chief mourner.
Yeah, I think the law also has things to say about that.
Alright, you're the lawyer, so tell us what the law has to
Alright,
say.
let's see. From the beginning, you will have this says, if in event of eventuality, who do we contact that can assist us get across to your family? Next of kin does not necessarily have to be a family member. Next of kin does not in any way have to be a blood relation that my family, just in case of anything. If you are joining a bus, the boss will ask, you hear them asking the boss, if they give you a manifest form to fill, next of kin, relationship. What is your relationship with that next of kin? Father or mother or brother. Friendship is enough to survive as next of kin. So people always have this impression that inherited properties, it is absolutely untruth, right? Now, Hannah, now we know that.
If that
Yes, tell me that.
no, I'm asking you.
I don't think there's any other next kindred, from the word kindred.
Yeah,
Next of kin
kin has to be kin. I believe is
related to you, right? No, but in law it doesn't mean so.
that's
In
why
law
I
it doesn't
said
carry any legal connotation. In law it simply says this man had said, I call this person if something happens to me. So call him. The first person to call is that person. And say that's his father, that's his mother, that's his brothers and sisters. Because people could be related by blood, but not related by socials. That means I might be the one conducting my affairs. All right, so moving from there, let's understand the other aspect of inheritance. Legacy and intestacy means
that
inheritance, a will,
does not have
or does not have a will. So let's have from you what's your understanding of the two.
So, if somebody has died without such a document and giving specific instructions on who is to own which property, that person is said to be intestate.
Okay.
So there is no statement when a person has a will. It's already there.
Settled.
How the owner of the property wanted his property to be distributed. So there is no issues. Some parties say we're going to contest the will. How does it end? The dead person is not there to say I wrote it or I didn't write this. So what happens when in court when wills are contested?
Okay. Well, when it's read and people will want to contest it, people have right to contest if they feel, as at the time this will was written, my dad should have died. Okay? So how was the will made when he wasn't alive? At the time this will was made, my dad was incapacitated. He couldn't properties that has been too lopsided. I was omitted and others were omitted for no just cause. A particular, if there were multiple, if it was the others could be that whilst the will was made, people influenced it. For instance, I sat with you and say, okay, I want to write my will that I will have my property to you. It can be contested. Why would that be? If not that you had influence on me. All right? Okay, so at the beginning, we want to say that upon the date of a person, there are 2 to 3 options open to him. One, if the testator, the dead person governing his estate, will be the governing the customary law or Islamic law of his ancestry or village or community. Now, the law so respects that position that wills, it is usually said that the first son would inherit the obi of his father. That is where the father had the final, call it the final, his palo. Okay? The first son will usually inherit that. Okay? But if in the will, he gave that to the first son. The will is English. Let's not forget. Writing a will is not local. The first baseline is religion, culture determines how a man's properties will be shared. Religion, Muslims. If it was a Muslim and the rest of them, is the distribution is in that range. Okay. So where they failed to write a will, that should naturally be the guy. That is not so. There is another provision that his estate falls under the care of the chief judge of the state. It's like in Akwa. Nothing until you now apply for letters of administration. In matrimonial causes, a wife that was married under the act.
Okay.
It's actually marriage under the act. That's a marriage that can be dissolved by the court. The only marriage that can be dissolved under customary. That's customary.
When you said
No,
marriage
by the High Court.
Divided by court.
Yeah, by the High Court.
Customary court is a court.
I like that. That's a good position. No, but the High Court has powers to dissolve the marriage.
Want to dissolve a marriage, that was conducted based on traditional rights, you just go return the dowry. When does the customary court come in?
If you were married to change your name from your maiden name,
Yeah.
which has affected your certificate, eventually you've returned the dowry. Don't forget, the governor does not know you are no longer married.
Okay.
A lot of people don't know. So the basic thing to do is to go to the customary court, which is district court in Ibadan. No, it's invalid. It's very valid. After all, you don't need to do the traditional marriage in the large way. If I come to your father and give me a bottle of wine and he accepts it, I'm your wife. You're my wife. I'm your husband. There's no hard and fast rule about it. It's about acceptance. And you are asked a question about who is the most possible candidate for letters of administration. And I say the most possible candidate will be one, the wife if married, and if the children are minor.
Okay.
Children of the deceased. When I said wife, it included the husbands too. Then the children, then the friends.
Oh, okay.
The parents.
Okay.
Okay. So, but
to join to apply for
4
letter
people
of
can join and
administration.
apply for letters of administration.
Okay.
So not more than 4 at a time.
Okay.
Now, why did I include friends? If a man or a woman can die intestate without anybody to take letters of administration except the friends.
What happens when a person applies for a letter of administration?
Okay.
You come and say, I was his friend.
It's a publication.
Okay.
So you publish it in a local newspaper, at least of that area, where it is widely read. In Akwa Ibom, we usually use pound, yeah? So administration, as regards to this estate. Anybody that's interested in contesting for that position will file a caveat.
Okay.
Telling the court to beware, don't fisheries of that estate.
And are you required to prove the person is not a direct beneficiary?
Yes, if you think you have a higher claim,
okay,
you come out and say, that person that is deceased is my father, I'm the first son.
Okay.
Wife.
Yes.
Are there other wives?
Okay.
Are there other children?
Okay.
They must be that disclosure. Okay. And when you disclose the fact that they are wives and children, they will be expected to come and young enough to run with the letters of administration can be picked alongside other administrators of the estate. By other administrators, in my family, it could be the eldest wife, my mom could be the family, not necessarily the children.
Okay.
But the law would encourage all 4, such that when they are sharing anything, all of them are in the know.
Okay.
If you're signing a check, all 4 will sign.
So the purpose of a letter of administration is the court empowering the people who are granted the letters of administration to share property.
Maybe outright sharing, maybe sharing of profits, maybe sharing of rents. Okay, for instance, a man has 2 cars and 6 children.
Yes.
And he requires an apartment to start his hospital. So, when that happens, the older son, who is a taxi driver, might preface it as though you were the owner, but dealing with it in trust for the beneficiary owners.
That's
and ensuring that the estate don't go into waste.
So what if the beneficiaries are not satisfied with your only accepted when I am the owner of the property, I decide to give it to my dog.
Okay.
Keep quiet. The owner decided to, but when somebody is administering by the power of the letters of administration, sharing formula,
Well,
does the law say that they have to accept it?
No, in the first place, letters of administration are granted most times in the line of priority to the priority relationship to make the fortunes of the estate without carrying other members along. The law expects the other members to file an application for account.
Okay.
He'll be asked to provide an account of what is ample opportunity for other parties to be joined as co-administrators in that estate.
Well, you said it's only 4 people who can.
Yes, 4 by 4. I mean, if there was one person and that person is administering it wrongly,
Yes.
another person can file an application to be joined as a second administrator, or second and third administrator, or second, third, and fourth administrator. They still have powers to go to court and ask the court to look at the accounts of the estate.
And so at the end of the day, the courts will be the one that now says, do it this way, do it that way.
Exactly.
Okay, that's what
Exactly,
I wanted
because
to
the
hear.
court will want to see, like, for instance, how many beneficiaries are there in this estate, and if they, all right. So we will also open the phone lines in 3 minutes time, and we will expect that you will have callers calling and ask questions, probably also contribute, especially those that have had real life experience on probate administration in Akwa Ibom State. So very soon I will reel out the number. We started out by saying that next of kin is not equal to inheritance of properties. We've also, I hope we have said too that properties include, in this case, include real and personal properties. By real properties, we mean houses. Expensive it is, still called personal properties, shoes, belts, and food items.
What about money?
Money,
and
see,
stock.
money pay a tax on the existing properties, which is why a lot of people prefer wills to letters of administration, because letters of administration would take from this and you just have to pay with the lawyer.
Okay.
But when you now want to file letters of administration for letters of administration, it becomes expensive. The tax part of it. I've seen somebody work, you refund the loan to the bank.
Which money comes in?
When the money in the account fall through.
Oh, you
Because
take
they
a loan.
take a 10% of whatever is in the account is taken as tax.
Yes.
So if the order of the
How do they draw the 10 million from the account?
okay.
You're expected to pay before you even get to letter of administration?
Yes, when you get to letters to apply, when you take to the banks will write the account numbers and details of how much was in their account. So you can go to any bank you suspected side with what you have applied for and confirm it's a person. They'll write the amounts in the person's account.
Yes.
As soon as they see that, they'll freeze the account, write the amount in the person's account, and you take it back to probate. And probate will ask you to pay a tax on that amount, the figures there. All right, the numbers to call 222-310-11. The alternative number to call will be 070-541-707. 541-770 what's dying tested. Dying tested simply means you die without a will.
Yeah.
Dying tested means you die with a will. You've written your will, identified who should own your property, identify what they should. You are to legally speaking.
Okay.
Hello, sir. Can you tell us your name and where you're calling from? All right. Probably the caller just wanted to get our attention, and he's gotten our attention. We want to confirm that we are sure. So
yeah, you said
you publish for 21 days that these following persons are interested in taking the estate off, administering the estate. You don't know them. Registrar, please pause. They'll file a caveat.
yeah, you said that.
So with that caveat, you are compelled to come out and answer questions. Probate court is actually the court is actually manned by a magistrate. In Akwa Ibom, it's manned by the chief registrar. It's sui generis court, you know. It's sorry. It's a it's a court that has its own rules and designed for.
Okay,
specifically for the purpose
so
of
a
administration
private
of the
court
estate of
is
this person.
a court just like we have a revenue court
Yes.
that deals with
Revenue.
what does it deal with?
Revenue, taxes, and just that.
Okay, so a private court deals with
Administration of estate of a deceased person. management and administration of the estate of the deceased person.
Okay, so that's where people go to. Okay, even that means even when you want to contest it with
Custody the will when it is made and given a will number. So they read the will when the person is deceased.
Oh.
Yes, it's the probate court that reads the will. Now, if anybody has
but
issues,
that's not what I used to see in movies.
yes,
I see.
empowered to.
Okay.
But when a will is registered and given a will number at the probate court,
Okay.
you go to the probate court on a date assigned to all parties that are interested parties. So to the court, which in this case is the High Court.
Okay.
Get the demarcation.
Yeah.
You go to the High Court to contest the will on one hand. On a second hand, where they that out before the probate registrar would issue clearance for letters of administration, which will be signed by the chief judge.
So the process is when I feel like I am the best before the publication for 21
go to the probate
days.
court, buy an application form, and the forms would include payment for publication. The publication will be made and it will stand for 21 days. After 21 days, you now come in with the documents you were given from the bank to the banks.
28th May 2023. Do I make another publication?
No,
what it means is that 21 days after the publication, if nobody comes, don't come again.
No, yes, if no, you can come because the publication is not sacrosanct.
Okay.
That A has taken letters of administration. The law expects that I file an application to be joined as a co-administrator, or to say don't even allow the person to administer the estate.
What?
Already issued. The law says the person that had that letters of administration, if he had sold any property, that sale remains valid.
Okay.
So you that is seeing it late, you're coming to challenge the man had no title. He had title to sell. Because at the point he was enjoying the authority of
that's
the chief
what I'm
judge.
saying.
So
that's why I wanted to be clear about what is the purpose of the 21 days. And you're now saying that if I come and he has already sold, there's no remedy.
Yes.
Okay.
There's no remedy. The only remedy you have is to go to court. And when you go to court, the court will say, well, where you failed to apply, another person did apply and took the property and sold.
Wow.
They're coming to say it's not entitled to. I was not informed. The publication day is deemed to be noticed to the whole world. So
what's the purpose of the 21 days?
Before I get to the purpose of the 21, 454 17707. Yes, the purpose of the 21 days. You cannot publish forever. The publication cannot run forever. It kills businesses. It kills a lot of things. So the least you could do is to get that publication out there.
Yes.
And 3 weeks minimum. It could be more, but 3 weeks minimum time. Other people through the fraud, if it was a fraud.
Yes.
So
after the 21 days, how long does it take before letters are
contingencies happening?
Okay.
For one, if the chief judge is in the office, because upon payment, upon the publication for 21 days, you go back to the estate, the probate. Personal. No, if you are applying for personal or they are together.
Okay.
Because you'll be expected to list the properties of the deceased person, including his real estate. Okay. So they will do an assessment and tell you this is how much you pay for these letters of administration. So upon such payment, guarantors will have to sign like a bond. You bring witnesses who sign for you. When all the documents are intact, the files are moved to the office of the chief judge, who signs the chief registrar, who would have earlier signed before the chief judge gives you the final signing, and it will now be sealed. It will now be sealed.
How long?
The process, that work that has to be done. Sometimes the files on probate could be as much as 100. In fact, usually it should be about 60 before it is moved for publication. So when you have 60 or 100 names, you move the publication. It's about 60 to 100 names. So when they come back and you have such number of files, the chief judge has to assign files to, has to sit in court.
Exactly. Okay.
Yes.
You talked about a wife, and if you were separated and one person dies, the other spouse is still a spouse that can apply for letter of administration.
Yes. So the numbers to call if you are trying to call him is on 07. Yes, you've asked a question that's happening on a regular basis. People get married, maybe under the act, all others. Then somewhere in the future, there's a discordant note in the marriage, and one person packs his things and leaves. He can live for 20 years, but he has left. He's entitled to inheriting everything he has had. So that is why you see people try to avoid what they call white wedding or
the regular man wondering, this woman left me and I died, and the person, if I had a will, I wouldn't have included her in my will because I'm dead.
She can come and
no, she might not just can come. She walks in there. Divorce. If there is none, then she is entitled to. She's just flying kites with her marriage certificate. She goes to the police and say, "My husband is dead." I'll be like, "What is going on here? You have a husband?" You say, "Yes." Exclusion of all others. So all of you have to leave the property for her. So that's how it is with the law. The law tries to protect that marriage. Okay. If the husband was smart, even with that marriage subsisting, he then will write a will.
Supposed to own property and write wills when they die.
Okay.
So I understand that people don't want to write. We are quite religious and spiritual here.
Okay.
So writing a will makes it look as if you're
a spouse or a party writes a will. It doesn't make him die or live. The will does not say I'm going to die. The will simply says, if eventually I die, an individual, formally speaking, a lawyer does the writing of a will. Formally speaking. Yet again, and this is what, but the contents of the will will be done after his dead.
okay.
Which is why people say
That's how it's supposed to be.
But upon his date, it activates itself. So a blind person.
So that means that you're talking about a blind person, yeah.
Okay, you want to ask a question?
No, I'm still thinking about the divorce or the separation thing. To share my property with the spouse.
I'm telling you we speak, because if that's your spouse gets your head off, the only thing you hear is he survived by. They don't even need to put her name.
Yeah.
If it is established that there has been a will in line with the traditions of law, that will supersedes every other thing. Literate for an illiterate.
How does the blind person
know that the lawyer has written his wish?
Okay, this is how it works. If I am a blind person, I want to alter my will. A lawyer is invited it over to the testator in the presence of witnesses, 2 witnesses. Upon the reading of the will, you must inscribe will today. I have listened to the lawyer who has read the will, and if he's illiterate, interpreted same to me.
the blind and deaf person?
Guess what, right?
How would the deaf person hear what?
The blind and deaf person will have witnesses document because they have become his eyes and ears. And I wonder how he had property being blind and.
What do you mean by you wonder how he had property being blind?
Okay, stating the condition of the person stating that this will has been read over to him.
So these
And
witnesses,
he's satisfied that this is what he briefed him to do. And upon that satisfaction, he has thumbprinted.
can't hear, this person can't see.
No, wait, you see, that's the other part. When you talk about a blind person, you seem to generalize darkness in the eye, forgetting that it's a braille where you can also
There's a
read.
braille. I am talking about a blind. Yes, so I know, okay, this reliable witness of mine is here.
Okay.
But I'm deaf and I'm blind.
Then
Where are the witnesses from?
the witnesses will be his witnesses.
That's what I'm saying.
Usually,
how
because
does he
the
know that
testator-
those witnesses are the ones that are present there
Yeah,
at the signing?
because they are special healings. So you come in and he touches your hand and say, this is Esau, not Jacob.
Okay.
And based on that, he can trust what he does.
Okay.
Okay. So he has to rely on the third parties who are not taking over the distribution of the estate of a deceased person. We have also considered that a will can set off the institution of truth. You cannot render your dependent destitute.
Is that in Nigeria?
Yes, that's in Nigeria.
Okay, because I watched in
for-
movies where
When you make
the owner of a
when you write
property
a
says,
will,
I give to charity, and
the law says no.
in Nigeria.
Yes.
Okay.
No, you can give to charity. What I mean is this.
No, what I mean
you have
is-
5 children
that's what I'm
depending on
saying.
you. Minus.
Okay,
Then upon your death, you will everything off and ask that they.
And they decide, I worked hard, you want to come and be lazy and feed off, so I'm not giving you, I'm
Okay.
giving to charity.
Okay.
So are you saying in Nigeria it can't be done that way?
No,
The
in
court
Nigeria-
will say,
in
no, it
Nigeria,
has to
it
go
can
to
be
your
done-
children.
It can be done, but the court would force things from that estate to the children because you cannot render them destitute. You brought them to this world.
No, they are not.
It will to be different if you were a minor. Okay? So, and now, if you write a will and say, don't sell my property, if it is taken up with that will, the sale will be void. Okay? It's not just, it's a voidable sale. If it is challenged, it will be void.
Wow. So the person that bought my property, I have to ask, the owner of this property, is he alive or dead?
It is
Where's
called-
your title
it is-
to the
yeah,
property?
It is called search. That's why lawyers take a fee to conduct those searches. Interest in that property.
So this search, how would this search tell you that there was a will that
That
said
is-
this property
yes. Most
cannot be
wills-
sold
most
until the
wills-
fourth
wills are
generation?
registered. Wills are registered. So if you go to a probate court, you can apply for a copy of that will. Expected to have a copy of the will. They can apply for a certified copy. So if they want to sell the property, they show you the certified copy of the will that this property rightly belongs to me by virtue of this will registered here.
They might see very well that the testator had said it shouldn't be sold,
Yes.
and he wants to sell it and get money, and doesn't show you. So are you advising a person that wants to buy property to ask for a will?
To be diligent, not necessarily a will. See, from the culture we've come from, wills have not been very okay. Akpan, you take this one, you take this one, and where they all agree to do that, it stands. The law takes it as a binding agreement, so it doesn't have to be in writing at all times. Sometimes parole, oral, can work. By parole, it doesn't matter. The law does not follow truth. The law follows facts. As long as there are people coming to confirm that this is so, the law is not expected to be a magician. It's supposed to rely on those testimonies and try as much as possible to weigh it.
Okay, so what we've said today, we've clarified the fact that you're being named next of kin in the eyes of the law doesn't mean that
you have any
you're the
proprietary right
you're
to
the
properties
one
of the
who
person.
you're the one who's to inherit upon my death.
Yes.
I name you my next of kin. It doesn't mean that you're the one to inherit my property upon my death.
Yes.
Then if there is no will, that's what we've talked about today. How to
You
get
have to
letter
pay
of
cost of
administration and
letters of administration and so on, which would have been waived simply by a will, and you pay a token to the you pay to the law.
of your property.
Yes, because
Okay.
it's happening and a lot of fights are going on. People are killing themselves because a man and woman failed to write a will when they had to write a will.
Okay, so this is minors as children.
Okay.
The brothers kick the wife out of the property and take over.
Okay.
So what you're saying is what the wife simply, uncles and brothers had
It doesn't matter.
taken over the property.
You see, so far the properties are real properties. The moment an action is filed in court, you join them. They are supposed to be the defendant. The court will grant an injunction that they stay action until family court and starts the property aspect of it will be at the High Court. The family court will award a speedy dispensation of justice for those children, in the best interest of those children. As soon as you arrive court, they will make consequential necessary orders to keep those children, school fees, feeding, accommodation, and drugs administration.
Yeah.
And you notice that there are issues surrounding, there's a threat to the selling of the property. Even if they sell it, it can be reversed. They didn't sell it with any authority. You now have the authority. So you can reverse it. I think one person got across.
And said hello.
And said hello, that's good. All right. Having with Hannah, I said, my name is Anthony, a book. I'm a legal practitioner with Law Partners and Associates. I believe everything you do from now until next week, Friday, will be
have to share police powers with the president as stipulated by the Constitution. We do not have a federal government police force. We have the Nigeria Police Force, which shall be administered, organized.
The scope of people who should be invited here for examination. My Lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers, is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court.
Is this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be...
Every Friday from 5 p.m. to 6 p.m.